Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Hello, and thank you for joining us for this month's Third Thursday webinar. My name is Evelyn Pacino, and I am the Executive Director of Pooled Trust Services. Before we get started, I'm going to take a moment to discuss the services Synergy offers to help trial lawyers do what they do best. We handle resolution of a variety of different lien types, and we have experts in every type of lien to ensure the best result for your client. We also assist with Medicare compliance, helping you understand what your client needs to do to comply with the Medicare Secondary Payer Act. We also offer settlement consulting, including attendance at mediations both over the phone and in person, and we have a team dedicated to creating structured settlements to help your client make the most of their recovery. We also offer trust services and administration so that your client can keep their public benefits and get assistance managing their funds long term. And finally, we can help you defer your attorney fees as a tax saving strategy. So let's get started. My presentation today is all about public benefits preservation. This is a very important area to be aware of because not only can it hurt your client, it can hurt you as the attorney as well. So this is me. I am an attorney licensed in the state of Florida. I specialized in elder law in law school, which gave me a foundation for assisting clients with disabilities, many of whom rely on public benefits. Prior to my career in law, I also spent 8 years in the Medicare Advantage industry. I am now the director of the Trust Services Division here at Synergy. My team administers trusts for over 350 people, the majority of whom have at least one of the benefits we will discuss shortly. Most of our clients are in special needs trusts, but we also have trust solutions for settlement management or preservation, MSAs, medical management, and QSFs. Here's our roadmap, which shows what we're going to cover today. We will review some of the relevant case law, the major public benefit programs, what you can do to protect your client's benefits, and some best practices for you as the attorney. Then we'll end with a brief question and answer session. So let's begin with a couple of cases which illustrate why this is such an important topic. First, we'll discuss the Grillo case. This was a birth injury case where the attorneys rejected a $240 million structure in favor of a $2.5 million lump sum. Not only did this leave very little money for Miss Grillo, who would need round-the-clock care for the rest of her life, she was not able to qualify for Medicaid or any other public benefits because there was no special needs trust established. Ultimately, the attorney and the guardian ad litem were liable for over $4 million in the malpractice suit. And then there's the Glorioso case. In that case, the client was not Medicaid eligible at the time of her injury, but she became Medicaid eligible while the case was pending. This is not unusual, as many injury victims are self-sufficient before their accident, but are left unable to work and need treatment of their injuries, so they turn to Medicaid. In this case, the proceeds were kept in the attorney's trust account for over a year, long after she was entitled to collect her money, which made it a countable resource according to Medicaid. However, in this case, the attorney was not liable, and that's because he was able to show that he had counseled the client regarding what she needed to do to protect her Medicaid eligibility. What this means is that you don't necessarily have to preserve the client's benefits. What's important is that you identify these issues, that you gather the best options for them, and then counsel them on what those options are. Now we'll get into the major public benefit programs. I want to start with the caveat that we cannot possibly cover all of the available programs in an hour. nor can we cover these programs in much depth. But the goal here is to introduce you to these programs so that you know what to look for and when to dig further. Before we dive in, it's important to understand that benefits fall into two categories: entitlement benefits and means-tested benefits. Entitlement benefits have no financial qualifications, so the client could get $1 million and it wouldn't affect those benefits. Means-tested benefits, however, are impacted by additional income or assets. So if you have a client with these benefits, they need to do something to protect their eligibility, and we'll talk about what they can do later in the presentation. You also need to think about deeming. If you're not familiar with deeming, the concept is that income is deemed between people who have a legal relationship to support someone else. So this applies between spouses and from parents to minor children. What this means is that income received by one spouse will be counted as belonging to both spouses, and income received by a parent will be counted as belonging to the child. So it's not just your client you have to worry about. And if the client, spouse, or child is receiving part of the recovery, you need to take steps to protect the money just like if the client was receiving it themselves. In some cases, there is no way to protect the money received by a parent or spouse, which in some cases results in having to forego consortium claims. It's also important to remember that these benefits are administered by state, federal, and local agencies, and that the rules are often different from jurisdiction to jurisdiction. And finally, one size does not fit all, both in the benefits a person can have and in the solutions needed to protect their eligibility. We're going to start out with the two programs that are always entitlement benefits, SSDI and Medicare. SSDI is administered by the Social Security Administration, and those who qualify receive a monthly check of about $800 to $1,800, but sometimes it's more. To qualify, the individual must be disabled and must have enough work credits. Under the SSA's definition of disabled, a person must be unable to work, and if they are working, they need to be earning less than the substantial gainful employment threshold of $1,260 per month. People with SSDI often have Medicare, and we'll find out why that is on the next slide. I'm not going to spend much time talking about retirement and railroad benefits as part of this presentation. Just know that they are also entitlement benefits offered by the Social Security Administration. Moving on to Medicare. This is also a federal benefit administered by the Centers for Medicare and Medicaid Services, also known as CMS. Medicare is health insurance. There are 4 components to Medicare. There's Part A, which covers inpatient care like hospital stays and skilled nursing, and Part B, which covers outpatient care like doctor's office visits. Parts A and B are what is known as Original Medicare. There's also Part D, which covers prescription drugs. And I didn't forget Part C, but it's easier to discuss at the end because Part C is the combination of A, B, and D. Part C is what's known as Medicare Advantage, which is basically Medicare that's administered by private HMOs. So your client might have a card from Humana, United, Blue Cross, etc. To qualify for Medicare, you must be age 65 or older or disabled, meaning you have to have received SSDI for at least 24 months or have been diagnosed with ESRD. Medicare is an entitlement benefit, meaning it won't be impacted by receipt of settlement dollars. However, if your client is still treating for their injuries, consider whether a Medicare set-aside is necessary. An MSA is an account the client can set up for the purpose of paying anything that is both injury-related and Medicare payable. MSAs are tricky because they aren't technically required, but Medicare does require that you take their future interest into account, and their preferred method for doing this is with an MSA. If an MSA is not created when it should have been, Medicare could deny coverage down the road. So for that reason, some think of it like an insurance policy. They'll set up the MSA as an insurance that there will always be money to pay for their claims. Finally, you should understand that failing to comply with obligations under the Medicare Secondary Payer Act can result in malpractice for the attorney. I'm not going to explore that in depth here because it's an area of specialty unto itself. But if you want to learn more about this, we have webinars on this topic on YouTube, articles on the Synergy blog, and of course, you're always welcome to call and schedule a consultation. Now we'll move on to the means-tested benefits. First is Supplemental Security Income, or SSI, which is also administered by the Social Security Administration. It's very easy to get this confused with SSDI because they sound so similar. Clients often don't even know what they have. The only way to know for sure is to look at the award letter. And if the client no longer has their award letter, they can request a new one from the Social Security Administration. SSI is a monthly payment of up to $783 for a single person or $1,175 for a married couple. If someone is receiving more than that, then they probably don't have SSI. I say probably because some states do supplement SSI payments, but it's rare. So you have to look at the award letter to know whether or not the person is getting SSI or SSDI. It's also important to note that SSI is intended to provide for a person's food and shelter needs, including rent, for the month. And yes, $783 is unrealistic, but that's what it is. To qualify for SSI, you have to be over 64, blind, and disabled, and you need to have limited income and resources. SSI and all the other means tested programs differentiate between what is countable and what is not. Fortunately, a person's home, vehicle, the items in their home, among other things, are not countable by the SSA. Any cash they receive, stocks, bonds, or even items held solely for their value are countable. If someone exceeds this limit, which is currently $2,000 for an individual, their benefits will be reduced or they might lose them altogether. People with SSI often have Medicaid, which we'll learn more about on the next slide. Medicaid is administered by state agencies. It's health insurance, like Medicare. Qualifications vary by state, but generally a person must demonstrate both a medical need and a financial need. The rules on income and assets are similar to SSI's rules, but they're not exactly the same. In some places, Medicaid is more restrictive than SSI, and in others, it's more generous. It all depends on the state and the form of Medicaid. In most states, commonly known as 1634 states, qualifying for SSI also qualifies you for Medicaid. This is important because the converse is also true. Losing SSI means losing Medicaid. And we often hear from clients who don't want to take the steps to preserve their eligibility because the settlement seems like a lot of money, and it's usually more money than they've ever had before, and they don't really care about losing their SSI. It's only $700 anyway. However, if they're qualifying for Medicaid through SSI, then they need to think twice about that. They could get private health insurance and private pay their care. And if the settlement is big enough, then maybe that makes sense. But in most cases, if they're going to make their settlement money last as long as possible, then they need to keep getting SSI and Medicaid. It's also important to note that Medicaid, unlike Medicare, covers long-term skilled nursing or nursing home care. And if that's something that your client needs now or will need in the near future, then preserving their Medicaid eligibility is critical because private paying that care is extremely expensive. While Medicaid is generally means tested, not all Medicaid programs are, particularly those for children. So again, it's important to dig into exactly what benefits your client has by looking at their award letter. If the client no longer has their award letter, then they can request a new one, and in some places they can even do that online. Okay, so let's make a quick pit stop to review what we learned so far, because this is where people usually have the most confusion. The entitlement benefits are SSDI and Medicare. The means tested benefits are SSI and Medicaid. SSI and Medicaid are income or asset sensitive. So if your client has one of those benefits, you need to be talking to them about what they can do to preserve them. SSDI and SSI are monthly payments the client receives. While these are intended to cover basic needs, there are no restrictions on what the client actually spends their money on. One way to tell the difference is to look at the amount of the check. If it's over $783, it's most likely not going to be SSI, it's probably SSDI, but again, you have to confirm with the award letter. Medicaid and Medicare are health insurance, not monthly payments as some people believe. Some people have cute mnemonics for remembering the difference. For example, Medicaid has the word aid in it, which should remind you that it's for people who need financial help. And if you can remember that SSI is supplemental income, then that might help you remember that it supplements the income of someone who doesn't have very much. Do whatever works for you, even if that means that you go look it up every time. Moving on to housing benefits, commonly known as HUD or Section 8 vouchers. This program is managed by the U.S. Department of Housing and Urban Development, but it is administered by local housing authorities. For that reason, it's hard to talk about this benefit in general terms because it's administered on a city or county level. The rules in one area may vary significantly from the rules in a different area. This is a voucher program for people who need help paying rent. Typically, the voucher covers 60 to 70% of the rental value in a given area, so the voucher recipient is responsible for paying 30 to 40% themselves. The recipient can rent a place that is more expensive, but if so, they have to pay the difference in rent themselves. The amount covered by the voucher goes down as a person's income goes up until they no longer qualify. This program looks at family income, unlike some of the other programs which look at individual income. It also does not consider assets, but it does count the income produced by assets. So while it doesn't count assets directly, they are still accounted for. Interestingly, unlike the other benefits, HUD does not count insurance settlements or reimbursement of medical expenses, which means that your client's personal injury settlement is not going to be countable by HUD. So if your client only has HUD benefits, then maybe they don't need to take any action to preserve their eligibility. However, it is extremely rare that someone qualifies for HUD and they don't have SSI or Medicaid or some other needs-based benefit. So make sure you're looking at the whole picture when you counsel your client. Next up is SNAP benefits. So this program is formally known as food stamps. This benefit is administered by the state, and like HUD, they look at family income and resources, not just the income of the individual. This benefit is accessed through a debit card that the person can use at grocery stores. It's called an EBT card, and they can use it to buy uncooked, unprepared food. So think raw ingredients to cook a meal. They can also buy seeds and plants if they want to grow their own food. What they can't buy is hot food or prepared food. Can't buy alcohol, tobacco, vitamins, or any non-food items. Next, we'll discuss veterans benefits, which are administered by the Veterans Administration, which is a federal agency. These benefits can actually be either an entitlement benefit or a means-tested benefit. Disability-connected pensions typically are an entitlement benefit, and those are for people who have a service-connected disability. VA pensions, on the other hand, are for those who served but are not disabled as a result of their service. VA pensions do have an income and asset test, which means they can be impacted by the receipt of settlement funds. For the income test, they look at annual income. So they will take the award from the settlement and divide it by 12 to calculate the reduction in monthly benefits to the veteran. The reduced rate will apply for 12 months, and after 12 months, the veteran's benefits will go back to normal, assuming there were no other changes. For the asset test, there's a limit of just over $127,000 per year for both the veteran and the spouse. Like other benefits, the money can't be given away to reduce assets, but there are methods of reducing net worth to qualifying levels, such as spending money on medical services or home repairs, so long as those things are for fair market value. VA healthcare benefits are also means tested for purposes of determining copays. So to review, I list out the entitlement benefits and the means tested benefits here. Entitlement benefits are SSDI, Medicare, and disability connected VA pensions. And the means tested benefits are SSI, Medicaid, housing or Section 8 benefits, food stamps or SNAP benefits, and VA pensions. Now that you have an idea of what benefits to look out for, I'll discuss some of the ways that we can protect these benefits. The first option we'll discuss here is special needs trusts. This is the way to go if your client is disabled and they want to hang on to their money and keep their benefits. This is because any money that goes into a special needs trust is not countable by public benefit programs. So that means that clients can keep their SSI, they can keep their Medicaid, and they can keep the money from their settlement to improve their quality of life for years to come. A notable exception here is VA benefits. For whatever reason, the VA does count special needs trust as an asset. So if you have a client with VA benefits, it's best to speak with an elder law or special needs law attorney who specializes in this area to find out what options are available. There are two different kinds of special needs trusts, standalone trusts and pool trusts. A standalone trust is one that is created specifically for the client. So they have the power to select their own trustee and add some customization. However, standalone trusts can be costly and time-consuming to draft. The client would need to hire an elder law attorney to draft the trust from scratch, which could take months or weeks, and the attorney might charge $5,000 or $10,000 to do this. Anyone can serve as trustee, however, private banks are usually selected. Clients sometimes want a family member to serve in this capacity, but that can be very risky. There are a number of rules that we have to follow when administering special needs trusts to ensure that we don't run afoul of any of the rules or regulations in place for these programs. For that reason, private banks are often selected because they're knowledgeable in these areas, but they can be very expensive and most have minimum account size requirements. So some banks will require a deposit of $500,000 or $1 million, so they're not always the best option for a smaller settlement. Pooled trusts, on the other hand, are so named because many people can join them and their money is pooled for investment purposes to get better returns. So everyone's money is accounted for separately. No one client has access to anyone else's money, but they all share in the returns. This kind of trust can be joined quickly because it already exists. So the client just fills out a joinder, which is basically a contract adding them to the trust. Pooled special needs trusts are required by law to have a nonprofit company serving as trustee, so fees tend to be much lower than a private bank. The only downside to the client is that there's less flexibility because this is more of a one-size-fits-all type solution, and they don't get to choose their trustee. All special needs trusts have some kind of restrictions, the same restrictions. Any funds in the person's trust must be used for their sole benefit. They can't purchase gifts or give money to others or pay for someone else's share of common household bills. The client also can't pull cash out of the trust or have a check written to them because this would be countable income, which would cause them to lose their other benefits. Finally, there are also disbursement restrictions specific to different benefit programs because these trusts are meant to supplement other benefits, not replace them. For that reason, if someone has SSI, the trust can't be used for food or shelter expenses. But don't freak out, we have a solution for that on the next slide. So what can you use a special needs trust for? Most of our clients need to purchase a car or a home or make their home handicap accessible, like within the first year. Typically, they've been waiting to make those purchases for many years. They can also use a trust for monthly expenses like cell phone bill, cable bill, getting their hair cut, buying clothes, and even for fun things like going to the movies and going on vacation. A lot of people think that special needs trusts can only be used for medical purposes, but that's not true. They really can be used for anything that the client needs. Lastly, when a person dies, any money that's left in the trust is going to be used to pay back Medicaid for the services that they provided since the trust was created. So if this was sounding a little too good to be true, this is the rub. It's the reason that the person gets to have their benefits and gets to have their money. If there's enough money to pay back Medicaid in full, then any money left over can go to the beneficiary designated by the client. Another option to explore is an ABLE account. So it's kind of like a trust in that the funds aren't countable by any of the public benefit programs, but the client has full control over the account. There are no trustees, there's no trust administrators, it's a private bank account. They just have to use the money for qualified disability expenses. The law actually says that qualified disability expenses should be broadly interpreted to be really anything that the person can argue supports their disability. So that includes food and shelter. So where the trust can't pay for those things, an ABLE account can. There are two major limitations, however. The client had to be disabled prior to age 26. That doesn't mean they had to be diagnosed necessarily, but they do need to be able to show that their condition presented before that age. ABLE accounts are also limited to $15,000 per year, so often they can't be used for an entire settlement, but they can be used for a portion of the settlement, or they can be used in conjunction with a trust. So what some people do is they fund the trust with their settlement proceeds, and then the trust can deposit money into the ABLE account, which can then be used for food, shelter, and any other qualified disability expenses. There are ABLE programs in every state, so this is available to your client wherever they are. We really like Stable. They're the program out of Ohio, and their program's open to all 50 states. So anybody anywhere can sign up for a Stable account. But there's a directory of all ABLE accounts at ablenrc.org. The third option we'll discuss is a Spenddown. So this is where the client takes their settlement proceeds and they purchase non-countable resources. So as I just discussed, often clients have a laundry list of things that they've been waiting to buy: a home, vehicle, and they may need to make accessibility modifications to their home or their vehicle. They may have a lot of debt that's accrued while they've been waiting for their case to settle. And in some case, paying all of those things takes up the entire settlement. And if that's the case, there's really no need to set up a trust. There are some rules particular to timing and reporting, so be sure to consult with an elder law or disability law attorney who can help you understand what the rules are in your state. Lastly, I have a few best practices to share so you can make sure your client remains eligible for their benefits and you don't have a malpractice suit on your hands. So all you have to do is remember to read. First, review your client's benefits at intake and throughout the case. Remember Glorioso. She wasn't eligible for Medicaid when she was injured, but she did have Medicaid by the time the case settled. If you don't review your client's benefits periodically, at least before mediation, then you won't know that anything has changed and you won't know to have this conversation with them. Second, enlist experts early on to educate you and your client. Whether it's a local attorney who practices in this area or a company like Synergy, work with people who know these programs inside and out. Third, award letters. Get them, and get them every time. Most clients don't know what they have, but government benefit programs send the client a letter explaining what benefits they qualified for, and this is the only way to know for sure what benefits your client does or does not have. And finally, document your file regarding your client's decision and what you did to educate them. This is especially important if the client is choosing to forego any of their benefit programs. So any competent adult can say they don't want to have their benefits anymore, that they are okay losing their SSI and their Medicaid, and they're just going to take their money and go about their life. But have them sign something acknowledging that you counseled them on this matter and that they declined to take the action that would have preserved their public benefits. Well, that concludes my presentation. I hope you learned a few things about public benefits and what your responsibilities as an attorney are. And now we have a few minutes to take some questions. Okay, so we've got a couple of questions here. I have two that are kind of related, so I'm going to go ahead and tackle those together. The first one is the economic stimulus check going to be counted as income? And relatedly, are tax refunds counted as income? So both of those things are pretty topical right now. Fortunately, the answer to both is no. Um, so neither the economic stimulus check or the tax refund is going to be countable. And that's because the economic stimulus is actually a refundable tax credit. So again, neither tax credits or refunds are countable. And we know that that's the case because we have regulations that say that from the different public benefit programs. And we also have some statements from the SSA more recently confirming that the stimulus is actually not going to be counted. And just, kind of as an aside, the stimulus checks that went out in 2008 or 2009 also were not countable. So we're pretty confident that it's not going to cause any issues there. And this actually makes a lot of sense. It really wouldn't make sense for the government to send all these checks out and kick everyone off of their benefits just to have them need to get back on in a month or two. So, I mean, it makes sense that they're not going to count them. So I have another question here about what the average cost is for a pooled trust. That's going to vary. So, and as well as how the pricing is structured. So for our trust, we have like a one-time payment, and then there's an annual percentage as well. A lot of trusts kind of follow that structure. It's probably going to, be somewhere between like $500 and $1,000 to get started, and then the percentage could be anywhere from 0.5% to 3%. So it's really important to look at the fee structure for that trust because it might look really low at first, but then they might have like a whole menu of things that they're going to charge your client for. So, like for our trust, we just have one low annual fee of 1.5%, and that covers everything. That's their trustee fee, it's their management fee, it's their investment fee, everything is under that fee. Some trusts are going to charge by disbursement. They might break those fees out, so they might charge one trustee fee and a separate trustee, or a separate trust fee for investment purposes. So, again, you want to just explore that fee structure and find out how that's going to apply to your client, um, because some trusts also will change it based on how much is actually going into the trust as well. So it's a very client-specific question, a very trust-specific question. So you just have to talk to their people and find out what their fees are. Next question is, what if the guardian of a disabled individual elects to not set up a special needs trust? So that's going to be a really tough case. I don't know that there's really much that you can do as the personal injury attorney other than to make sure that that guardian has been counseled properly and that they have signed something saying that. So if they turn it down, it's on them. I don't know if there's anything you can do, to go to the court and make them set it up. Ultimately it's the guardian's call. All right, and it looks like I have some questions about what our setup costs and annual management costs are, as well as whether annual accounting is included in the fees as well. So our setup cost is $500. Our annual fee is 1.5%. And for us, again, that covers everything. So that includes annual accountings. I mean, really anything the client is going to need, anything that we're doing as trustee is going to be covered under that 1.5%. Moving on to the next question. Can a person be on Medicaid without being on SSI or SSDI? And so just to tackle that first piece, they could. They don't necessarily have to be on either of those benefits. I know I talked a little bit about how in some states qualifying for SSI automatically qualifies you for Medicaid, but that doesn't mean that you have to be on SSI to be on Medicaid. Different states have different programs and qualifications. So typically they are, but they don't necessarily have to be. Okay, and the second part of that question is, if so, does the settlement have to be reported to Medicaid? And if it is, if it pays a health insurance premium to temporarily suspend the health care insurance so funds received by the client are spent down. So I think what this question is asking, so first, does the settlement have to be reported to Medicaid? So the settlement itself, I think, would have to be reported to Medicaid as well as the creation of the trust. There is an obligation for anyone who has Medicaid, SSI, or any of these public benefits programs to keep those agencies updated in terms of what the person's income and resources are. So if they're getting a settlement and they're not reporting that, then they are committing fraud. All right, moving on to the next question. Does my client have to pay taxes on the money that they put into a special needs trust or an ABLE account? That's a great question. So it's an easy answer. No, the money that goes into a special needs trust or comes out of a special needs trust and goes into an ABLE account, comes out of an ABLE account, not taxable. What is taxable is if they have a trust, then the income that's earned on the money in the trust is taxable. So the true is not the same for ABLE accounts. ABLE accounts are never taxed. But with a special needs trust, the income is. And to elaborate on that a little bit and why it's structured the way it is, so special needs trusts are considered grantor trusts, meaning that they can either be taxed at the trust rate or they can be taxed at the beneficiary's rate. And since the trust tax rate is so much higher, it actually saves the client money for them to include that income on their personal income tax return. So for that reason, we issue a grantor letter, and it's also called a K-1, and that states how much income the trust subaccount, like the specific subaccount for that person, earned during that year. And so they take that K-1 or they take that grantor letter to their tax preparer along with all their other tax documents, and they can count that as part of their taxes, or I'm sorry, as part of their income. And it's worth noting here that they can also use the money in the trust to actually pay for that preparation as well as paying for the taxes themselves. All right, and moving on to the next question. So what if my client doesn't have any benefits? So that's a really great question. If the client doesn't have benefits right now, there are still two things that you want to think about. The first is, are they going to have any of these benefits in the future? So you should be thinking about whether they're going to need nursing home care, especially since that's a benefit that's provided by Medicaid. If they have any future medicals, are they going to be on Medicare in the next few years? Do they need to create an MSA? And so if the answer to that is yes, if they are potentially going to be on one of these benefits in the next few years, then you might want to think about having them set up a trust now. And one of the reasons for that is that when the person turns 65, a standalone special needs trust is no longer on the table. The law literally prohibits anyone over the age of 64 from creating a new special needs trust, a standalone special needs trust, or from adding any funding to a special needs trust that they already have. So after they turn 65, they can still join a pooled trust. However, if they have SSI, their SSI payments are going to be suspended, and in some states they're going to lose their Medicaid. So if you have a client who's in their 50s or early 60s, then this is something that they need to think about. Because typically you can always create a special needs trust at any time, but once they reach the age of 65, they might want to fund a special needs trust and not be able to anymore. The other thing that you need to think about is whether any of the family members in the household have any kind of public benefits. So, again, this is because of deeming. Any money that's received by a spouse is attributed to the other spouse. Money that's received by the parent is attributed to minor child. So you really need to be looking at the entire family. Right, moving on to the next question. It says, I've read that stimulus payments are going to be based on people's prior year's taxes or income. And my client has public benefits, but they don't have enough income to file taxes. So will they still get their stimulus payment? So basically what this is asking is, if someone's not filing taxes every year, how is the government going to know whether or not they qualify for the economic stimulus payment? Fortunately, if they don't have children, then and they do have SSI, they don't need to do anything. The IRS already knows about them. They've already said that they're going to send out these payments. And I think they're planning to do that in early May, is the last that I saw. If they do have children, then there's an IRS website that they need to go to so that they can report and claim those children and then get that additional $500 as part of their check. And I will give you that website now. You can probably Google your way into it, but if not, it's irs.gov/economic-impact-payments. That's plural. So again, irs.gov/coronavirus/economic-impact-payments. So, and they should look for the section called non-filers. And that website can actually be used by anyone to track their payment or to update their banking information. So, if you had a different bank account last year and now you want your stimulus payment to go to another payment or another bank account, you can actually have it sent to that bank, or if you change your mailing address. And it looks like that is all. So again, thank you so much for listening to our webinar and have a great day.